so much, Dorothy. I'm really glad to see everybody here. And thank you to the Arts Council of Rockland as well for inviting me. I'm Athreya Mathur. Thank you once again for the introduction. I work as the Director of Legal Research at the Center for Art Law. And once again, I'm very excited to be here instructing this workshop on copyright with you all. I will quickly share my screen, but just as a note, I would love to hear from everybody as well. So in case when we're going through any of this material, if you've gone through a certain legal issue or if something reminds you of the work that you've been doing, please feel free to answer your questions. And I'm very happy to hopefully answer all of them. So I am just sharing my screen and hopefully you are able to see that now. Yes. All right. So as a little note, the presentation and all of the information that I will be providing today, it is educational. It doesn't amount to any legal opinion or legal advice, or of course, create any attorney-client relationship. And also, as a fun note, the images that you see here, they were actually generated by Llama AI. So these are a lot of legal, ethical, and copyright considerations just from the images you're seeing on the screen right now. You might notice that there's a familiar painting in the background, maybe from someone who we know as Van Gogh. So in case you have any questions about this, we'll hopefully be able to get into copyright and artificial intelligence a little bit as well before we end the program. Now, today we are hoping to cover a bunch of different things about copyright, what it is, what does it protect, whether registration is necessary, and going into the crux of what appropriation is and what fair use is. And I also hear that a lot of artists like to share that they work that they do on social media. So I'm hoping that we have the time to discuss that as well to better understand how artists can protect their work while making it available to the public on various social media platforms. Now, before we really get into all of this, I'd like you to take a look at both of these photos. What do you think when you view these pieces? Do they look similar? Does it look like it's been done by the same artist? Do they invoke the same feeling? To give you a little backdrop of this case that you're seeing, Jeff Koons, who is a prominent visual artist and a very well-known appropriator, he made a collage using various photographs of women's feet, and this was for an exhibition that was commissioned by the Guggenheim. So this collage, which you can see on the right, it included a copyrighted photograph that was taken by a fashion photographer, Andrea Blank. Andrea's Blank, her photograph, which you can see on the left, it appeared in a fashion magazine called Allure, and it depicts a woman's legs reclining on a man's lap in an airplane cabin. And what Koons did is that he took this image, he cropped it, and he reoriented the photo, as you can see, before he included it in this painted collage among other pairs of women's legs. Now, the photo that was taken by this fashion photographer on the left, it depicts a woman's lower legs and feet. It's adorned with bronze nail polish and glittery Gucci sandals, and they're resting in a man's lap in what appears to be a first-class airplane cabin. And what Kuhn stated is that certain physical features of the legs in the photograph, it represented a particular type of woman who's frequently presented in advertising. He, through this collage that he made, he wanted to comment on commercial images in consumer culture. For him, it was a satire of life seen through the prism of slick fashion photography, in his words. But essentially, what he did, he appropriated an image, he took another person's photograph to comment on society and to create something new. And in this case, the court ultimately held that this was not copyright infringement. Now, I mentioned this just to show how copyright and art can be such a fascinating field. It can inspire a lot of questions and a lot of exceptions. And I hope to cover the basics, but also I'll likely leave you with a lot more questions than answers. But by the end, hopefully you will know how and why this case was decided as it was, and how, as an artist, you can create, but you can also respect the work of others and protect your own work as well through a very important tool known as copyright. But before we once again get into the legal bits of it, I do want to mention what is the purpose of copyright and what is the purpose of intellectual property. I think that this is really important for you to keep in mind, and it'll probably guide the discussion quite a bit throughout this presentation. So in the US Constitution, the Constitution actually states that the whole purpose of copyright and intellectual property is to promote the progress of science and the arts. And what this means is that while, of course, you're granted certain economic rights to protect your work and to gain economically from your creations, you are not necessarily trying to restrict others from creating. You're allowing creatives to secure those economic rights over the work, but the whole point of IP is to encourage creation and innovation rather than to stifle it. So this becomes really important because when you're considering intellectual property and copyright in this aspect, that means that there's a certain balance that you have to draw between how much of a work can you create and can you own, and who should be allowed to feel inspired by that work. So we'll be breaking down hopefully a lot of this, but I would suggest keeping this in mind as we go through all of the different components of copyright. Now, finally, we're going to touch upon the legal aspect of it all and define what exactly is copyright. Why is this so important? What does it mean? And what does it protect? So copyright, it is a type of intellectual property, and that means that it's a creation of your mind. And what copyright particularly protects is original works of authorship as soon as an author fixes work into a tangible medium of expression. We'll break all of those down very soon, but to understand that just at the outset, essentially copyright, it protects literary, dramatic, musical, and artistic works. Basically, you can see copyright all around you, whether it's poetry that you were mentioning earlier, novels, movies, songs, blog posts, architecture right in front of you. All of these, they likely have some copyrightable elements in it. But what copyright does not protect is ideas, systems, methods of operation, but it can protect how these are expressed. Now, it's also important to note that you have different forms of intellectual property that protect different things. So just because something isn't protected by copyright, it doesn't mean that it might not be protected by a different type of intellectual property. But for work to be protected under copyright, it needs to be more than just an idea. It has to be the expression of that idea or expression of that plan. To give you a very classic example, and one of my favorites, is rom-coms, romantic comedies. And if you are like me, even though you know exactly what is going to happen in the nth rom-com that you're watching, I still really love a good declaration of love at an airport cliche. And I can watch those movies a good few times, again and again. And while that movie is protected in itself, that idea of a grand gesture, a boombox, that airport chase scene, all of that cannot be protected. That's merely an idea. And the reason why that's done is so that other movie makers, other producers, they can use that idea and they can express it in a different way. And maybe one day we'll actually be surprised at the end of a rom-com. But the reason why these are not protected, and as I mentioned earlier, is because of the Constitution. The Constitution established copyright to promote science and art. So if you start granting monopoly rights or controlling access to the use of ideas, it would undermine exactly what copyright is meant for. Imagine we'd have to watch one rom-com for our whole lives. So the requirement of expression becomes so important in order for the objective of copyright law to be met. It enables the creators of new work to protect their expression of those ideas while you permit others to express those same ideas, but in very different ways. And as I mentioned earlier, just because something doesn't fall under copyright protection, if it's not a literary, dramatic, musical, artistic work, it doesn't mean that it could not be protected in other ways. There are other types of intellectual property, and while I won't go into the detail of that today, to keep in mind, you have patents and you have trademarks, and they cover work that is very separate from what copyright protects. For example, patents, those are granted by the government and they protect certain inventions and discoveries. And trademarks, on the other hand, they protect words, names, symbols, and they indicate the source of goods. So if you have a brand, if you have a logo, you'd rather have that protected by trademark rather than copyright, or even both if you're trying to protect different elements. But I would keep reminding you that just because it doesn't fall under copyright protection, ensure that maybe it could be protected under another form of intellectual property. So now you have a very basic idea of what copyright is. It protects these artistic expressions. But do you have to register a copyright in order to receive that protection? Do you have to register a copyright in order to have copyright over something that you've created? A really important point to note is that copyright registration is actually completely voluntary. Copyright, it exists the moment you create the work. So if I draw a sketch right now, if I write a poem right now, or a little doodle, no matter how cheesy it is or how bad it is, I own the copyright to it. It is my creation, it is a creation of my mind. And even without having to register that work, I have copyright over it. So why do people talk about registering copyright so often? What is the big deal? Well, the big deal is that even though you own copyright the minute you create something, if you ever wish to bring a lawsuit in federal court, you have to have a registered copyright. So while it isn't mandatory, it has a lot of benefits. One of the biggest being that it's the only way that you can actually sue in federal court. So if somebody is infringing your work, you need to have copyright protection in order to enable yourself to file a lawsuit and enforce your copyright in court. There have been several cases and even class action lawsuits. Right now, we're hearing so many class action lawsuits on AI generated art. And unfortunately, so many claims have been thrown out by the court because the works were not registered. And if your work isn't registered, you can't hold the claim in court. However, you can always go back, register your work, and then file a lawsuit again. But the downside of that is that it takes away the option to claim statutory damages, and you would have to prove actual damages. So the reason why people register their work is one, so that you can actually bring a case in federal court. Two, that you can claim statutory damages and attorney's fees. If you do not register your work, unfortunately, you can no longer claim statutory damages. And that is honestly the best bet of receiving any type of damages. Proving actual damages can be a lot more complicated. And very importantly, it's evidence that your copyright is valid. And this could be extremely important if somebody else brings a lawsuit against you for infringement. And finally, it puts others on notice that your work is protected by copyright and that you are the copyright owner. So it also serves as public record. So even though copyright, it is not mandatory to register at all, you can see that it has a lot of benefits. And if you ever think that you may have to initiate a lawsuit against somebody else, if you think that somebody is infringing your work, then ensure that your work is protected before you file an infringement lawsuit against another party. So now, once again, we have a little brief background on what copyright is and whether registration is necessary or not. But now we're going to go into the depths of copyright because in order to really protect your work or to understand fair use or to understand when somebody else is infringing your work, then you need to understand what can be protected and what other people could potentially see in your work and feel inspired by to create something of their own. So now we are going to look into the requirements of what can be protected from an artist's perspective. As I mentioned earlier, copyright, it protects original works of authorship once an author fixes them in a tangible medium of expression. So we're just going to go through a couple of the components of this definition of copyright. First, we're going to look at the authorship requirement. Then we're going to look at what tangible medium of expression means. And finally, we're going to understand what the component of originality is in order for work to receive copyright protection. The first component is really, really important because this is the authorship and ownership component. And when we talk about authorship, it's actually interesting that the Copyright Act in the US, it doesn't define who an author is. But generally, with copyright law, the creator the person who has made the work, whether it's the photographer who took a photo, the artist who painted a painting, they are referred to as the author of the work and the originator. Now, the person who has the rights to publish the work, modify the work, republish the work, they are known as the owners of the work. So there's a little difference between the author, who's the creator, and the person who actually has the legal rights over the work. And typically, the author is both the creator and also the owner of the works. That is something that is incredibly important for artists to know, that at the outset, you are always the author of the work and you are the person who owns all of the rights to your work. That belongs only to you, the copyright holder. However, there are certain exceptions. So, like I said, generally copyright is owned by the people who create it, the artist. But you have assigned rights, you have work for hire, and you have employer-employee relationships. Now, assigned rights is when, suppose you're an author and you write a manuscript, and then you assign and sell the ownership rights to a publishing company. So this means that the author, you have given up certain rights to the manuscript so that the publishing company can, of course, publish your book. So that's when you have assigned certain rights and the company or the other entity, they become the owner of the work. So while you are always still the copyright holder and the author of the work, you are assigning certain rights so that somebody else can kind of help you get your work out to the market that you need it to get out to. The next is work for hire. So this is when a writer, photographer, artist, you are hired by a business, an individual, or any other party really, who's a paying client, and they want you to create this work as part of a specific agreement. So these are usually known as work for hire arrangements. And of course, the client who pays for the work, they usually get the ownership rights to it. But once again, you're always the author and the copyright holder. Finally, you have employer-employee relationship, and this is what you see most common. So if you create something in the course of employment, then the employer usually owns the copyright. You see this in all types of instances. A video game developer, you develop a new video game on the company's money as part of employment, then the employer is usually the author and the owner of the work. This is a very general notion of who the author is and who the owner is, but the most important thing that I would take from this is to ensure that you never sign away these rights in any contract. At the outset, you are the one who holds them and you have the right to assign them. So we'll get into this in a little more detail when we talk about the rights that you have as a copyright owner, but just in terms of authorship and ownership, you should know that in order for copyright to exist, there needs to be an author. And the author needs to be a human author. To understand a little bit more about authorship, there's a really famous case, one of my favorites, known as the Naruto case. And in this case, we had David Slater. He's this British wildlife photographer, and he had set a camera up and he left the camera unattended. And a very handsome monkey named Naruto, he found this camera, he clicked the button while looking at the camera, and he captured these really striking selfies of himself. And what the wildlife photographer Slater, what he did is that he then published a book and it featured the selfie and it even featured other photos that had been taken by Naruto, the monkey. And in response to this, PETA, the People for Ethical Treatment of Animals, they filed a complaint against David Slater and the publishing company, and they represented Naruto. And they said that the right to own and benefit from the copyright in these monkey selfies, it should be in the same manner and to the same extent as any other human author. But the Copyright Office did not agree to that. They said that they would refuse to register a claim if it determined that a human being did not create the work. And very importantly, in this decision, the Copyright Office also said that it would exclude works that were produced by a machine or by a mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. So of course, I stress upon that the latter half of it as well, because while now we know and we have precedent that monkeys and animals cannot be authors, it also gives very strict guidelines on machines and potentially artificial intelligence ever being granted authorship to AI or any type of works that are created. So, coming very closely to that, I think it's important to mention one such AI related case, especially for visual artists who may notice that the rise of AI generated art is becoming extremely, extremely prominent. Now, the question is, we know that a monkey, an animal, can't ever be considered an author, but can AI be considered an author, or who owns authorship or copyright authorship to works that are generated by AI? So a really great example of this is in the US, we have Zarya of the Dawn, and this is actually a graphic novel, and it was created by an artist, Chris Castanova, and it's a comic where the artist she wrote the writings and the script, and then she used artificial intelligence to generate the images. And she slightly photoshopped the images to make it suit her requirements for the graphic novel. And then she had submitted this for copyright registration. And initially, the Copyright Office granted full copyright registration for that graphic novel, but later they rescinded protection over the images that were included in the novel since it included AI generated images and copyright protection is only granted to a human author. So there is no copyright protection for the images, even though edits were made by Photoshop by the artist. And what the Copyright Office stated is that the work in a whole, the selection and arrangement of the images and the text together, that could be granted copyright protection, but the AI generated images independently could not be. Only the human created portions of a work can be granted protection. So this is just becoming incredibly popular at the moment, and artists are really testing out the extent to which they can create with artificial intelligence. And the reason I'm really stressing upon this is because we have had artists come up to us who are either one, very cautious about artificial intelligence and they want nothing to do with it. We have another set of artists, though, who are learning how to create with AI, and they are spending hours and hours collaborating and trying to come up with an image using different AI software tools. And they're trying to see, how can I protect this work? Or could I ever protect this work because it contains AI generated output? So these are a lot of questions that we're waiting to hear answers from. But for the moment, AI cannot be granted authorship. It is only a human author. And if you are working with artificial intelligence, selection and arrangement of the human created elements can be protected, but not the AI images independently. Another very quick doctrine that I would like to mention under authorship is joint authorship. So, of course, if two artists come together and they try to create something, then you can have joint authorship and joint ownership of a work. And a really fun example to consider, though, of course, no, there hasn't been any lawsuit or any cases about this, is during COVID, something that got really, really popular were Zoom and FaceTime photo shoots. And I think it's interesting to think about joint authorship in this context. Essentially, usually when there's joint authorship over a work, and a very common example of this would be if you're co-writing an article together. Two people, they work so carefully, so closely that the purpose of the work is to create something in that joint capacity. But it's not always that clear cut. And these Zoom FaceTime photo shoots are a good example of that. In general, if you have a photographer, they are the ones who are considered as the authors of the photo. But in these type of photo shoots, the photographer, what they would do is simply screenshot an image. But the person on the other end, the model on the other end, they had more of a collaborative role. So depending upon the extent of contribution of the actors, there could be a claim for joint authorship. The models became responsible for the style, the setting, the theme, posing in certain ways, their hairstyle, their makeup. So they may have a claim if they decide such details and the extent of the collaboration. And this can be compared very easily to paparazzi photo shoots. And this became very contentious maybe 5, 6 years ago when a lot of celebrities, they were being sued by media companies for posting photos on their social media where they were the subject. And the media companies had simply taken the photos and they had uploaded a few of the ones that they liked. And a lot of the celebrities' claims were that we are the ones who posed for these photos. Shouldn't we have some authorship to it? And it was decided on a case-to-case basis. A lot of this was in private negotiations and settlements, but a photographer is the one who has ownership over the work. They are considered as the authors, especially if celebrities had taken the images from these media publishing websites and cropped off the name of the company that actually took the photos. That would clearly be infringement. Now, these are just a few examples for you to consider when you're thinking about authorship. But to sum up this factor and this criteria, in order for copyright to exist and in order for you to receive copyright protection, the first is that there has to be a human author to the work. And there can be joint authors depending upon the extent of collaboration and what was the mindset of both of the collaborators when they started working on the project. Now, the next factor is a tangible medium of expression. And it is slightly easier to understand. Essentially, what it means is that a work, it needs to be fixed in some kind of medium in order for it to be protected by copyright. It needs to exist for more than a transitory duration in order for the work to be perceived by the senses and to be passed on to somebody else. And to maybe break this up a little, there are three really important points to understand what this means. One, it has to be by the author or it has to be done under the authority of the author. So it needs to be fixed, but with the permission of the author. So, for example, if you record a concert on your phone without permission, that doesn't count as fixation for the purpose of copyright for that performance. You would, of course, have copyright in your video, but it would not mean that the performers had fixed it for the purpose of copyright. The next is permanence. So it has to be preserved in some kind of a permanent way, as I mentioned, so that it can be communicated to somebody else. And then finally, it has to be more than a transitory duration, but it can be fixed while it is being transmitted, such as a recording of a live TV segment as it goes over the air. Now, it's really interesting when we think about this because, to put it very simply, if you are an artist and you're painting on a canvas, automatically, of course, that's a tangible medium of expression. But it can get a little more complicated. For example, video games. You have signals that are there for less than seconds. But what the court held is that those signals, they can still be perceived while they're being transmitted. So that is why video games and the signals that are produced in video games are actually protected. And that's why they're granted copyright protection. Otherwise, this element is quite simple, that it has to be fixed in some kind of a tangible medium. But of course, I wouldn't stop it right here. I must add in some examples that make it more confusing to understand. So, one of my favorite cases, which really, really made me think about this requirement in particular, and even about the earlier requirement of authorship, is Kelly versus the Chicago Park District. And it is a fun case because an artist had planted wildflower works, and there were two enormous elliptical flower beds, and it featured a variety of different native wildflowers, and it was edged with borders of gravel, of steel. And the way this artist, Kelly, had promoted the work was as living art. And it received a lot of popular and critical acclaim. But of course, because it's outdoors and it's in the open, it began to deteriorate. So then the park district, they decided to dramatically modify this garden and they substantially reduced the size of these huge, enormous elliptical flower beds. And they essentially reconfigured them into small rectangles and they even changed the planting material. And what the court held was that Wildflower Works was a painting and a sculpture. But what they stated was that it wasn't original enough to qualify for copyright and it wasn't fixed, and also that there was no real author of the work. Now, this is a little troubling because when you look at this work, the artist Kelly had very intentionally planted these wildflower works in the open and in the garden, knowing that, of course, the season is going to change and the work may change along with the season. But what the court stated was that the artist, Kelly, didn't really play a great role in that. That the artist was no longer the real author of the work, but rather the weather started to play a really big role in shaping the work. So while the work was considered to be art and it was considered to be a painting, it lacked the criteria to protect it from copyright. So this is very nuanced because they said that yes, this is art, but no, this can't be protected under copyright. And there were multiple reasons that I still find concerning whenever I look at this case is because the intent of the artist was just not taken into consideration. That the purpose of the work was for it to be living art and for it to change. But what the court said is that it was not substantial enough in order to receive authorship. And very importantly, what the court stated is that natural materials, plants, flowers, resources, they cannot be granted copyright protection. And I think we can understand where that is coming from because, of course, we don't want to stifle creation and to kind of stifle other creators from creating with this work. But ultimately, the wildflower works by Kelly were not granted copyright protection. It wasn't fixed, the authorship was undefined, and they didn't think it was original enough. In New York, every year we have these beautiful mannequins. It's called Fleurs de Ville, and every September, October, they have the show in Hudson Yards. So if you're in the city, I would highly recommend stopping by during the season. But after I had read about the Kelly versus Chicago case, of course, magically, I came across this exhibition. And all I could think about is that these are flowers, these are natural materials, and these works were stunning. These are larger than life mannequins, and the gowns, the accessories, everything you're seeing in these images, they were created by different flowers, different materials. And the best part is that when you walked by them, each of these mannequins and gowns and accessories, it had a very different scent because different flowers were used to create each of these pieces. And I reached out to the creators of this, asking them if they ever copyrighted their work, because now you know a little bit more about copyright, right? That it needs to be a human author, it has to be fixed, and it has to be in a tangible medium of expression. And I thought that, of course, these would be granted copyright protection. But when I reached out to the creators, their first response was, we didn't even think about whether we had to copyright these or whether they would receive copyright protection or not. We assumed that it's art and it should be protected. So they actually never took into consideration any of the copyright concerns. So this isn't a case to share with you, but this is an example. And maybe for you to think that do you think that these would be granted copyright protection based on the information that we have? These are it is created by a human author and it is fixed in a tangible medium of expression. It is on a mannequin and you can perceive it for more than a transitory duration. And it is also indoors. So it's not like the weather is changing it, like what the case with Kelly versus Chicago Park District was. So I just think that this is a good example to show a couple of things. One, what the scope of copyright protection could be, and two, how very often copyright is not something that is in the minds of artists or creators when they're creating something so beautiful and extravagant as these mannequins that I came across. But this is once again just an idea for you to think over. The final oh, something else I actually wanted to mention here. I was talking about natural resources. Another thing I wanted to mention that food and perishable items, these are also not protected under copyright. However, something which I think can be forgotten at times is that if you take a photo of something, you own copyright to that photo. So if I've taken photos of these mannequins, I own copyright to this. And there was another case where there was cold frozen ramen and somebody wanted to copyright that as art. And the court once again held that yes, this could be considered as a food sculpture, but it can't be granted copyright protection. So what the artist did is that they took a lot of photos of it and they received copyright protection, of course, in the photos, not in the sculpture in itself. So that is a distinction that I just would like to make, that a photograph of something is very different, and having a copyright over a photograph is very different than having copyright over the actual work that you're trying to protect. So I'll get into this distinction maybe a little later as well, but just to keep in mind when you're working with natural resources and natural materials, that photographers have rights. And if you don't have proper agreements with photographers who are taking photos of your work, they could own the copyright in the photograph while you still own copyright in your original sculpture or work. So those are two separate copyrights that you either have to contract or that you have to take into consideration to protect your work. Now,
Triana, we have a
mhm,
question in the chat.
of
Um,
course.
does it mean that ephemeral art is not copyrighted?
Yes. So that is a very good question. Ephemeral art, conceptual art, it is difficult to copyright these types of work. A lot of times, what people try to do, or what artists try to do, is that they try to have a manifesto, or they try to have some kind of a presentation of what their work would be, and they try to copyright that in itself. But a lot of times, concept art that you can see, conceptual art, it's very difficult to copyright those unless there are additional components. So what artists have tried to do is that they try to copyright a collection of art together in order to receive copyright for the entire selection of works, or they try to have an auditory component, or they try to add in a different type of component to receive protection for it. One of the very interesting exhibits that I had seen, which inspired a a big part of me to pursue art law, was I had walked into this exhibition where there were only white canvases. There were only blank canvases, and there was an audio playing in the background of a young boy saying Monday. And then as you proceeded, the voice of that got to an older person saying Wednesday, Friday. And it was some kind of a time-space continuum that the artist was trying to produce. But all I could think about is, can these blank canvases ever be protected? And a lot of this is done on a case-by-case basis. It depends on what you're producing to the Copyright Office. And a lot of times, if you, for example, just use one color, or if you use um, a few portions of a particular type of work, a lot of times what the Copyright Office does is that they grant you very narrow protection over the work that you have. And what this means is that you have protection literally only of your work and of somebody exactly copying that work. Now, another person could produce something very similar to your work, and they would likely receive protection for their work too. So it becomes a little complicated and a little nuanced. And I always like to go back to the example of photography because I think that that can clarify a lot of things. If you are sitting with your friend and both of you take a photo of the exact same object, the exact same somebody scoring a winning goal, and you both capture the similar photo, both of you have protection in that work. It's just that no one can exactly take yours and reproduce it, but that doesn't stop somebody from having protection over their photograph or their version of exactly the same instance. It's just that you have extremely narrow protection over it. And this can raise a lot of very complicated questions that, one, is copyright really, is it really helpful? Is it really necessary at that point if anybody can create? Especially if you don't register the work, you can't really sue anybody for it. But when we get to the rights that you have with copyright, then I think it's helpful to understand why people want to at least show that even without registering the work, that you have protection over it. So even with conceptual art, and even for any kind of art that you can't really process or see, you could have copyright in that without registering it. So I'm not sure if I have really answer that, or if I've made it a little more complicated to answer it. But regardless of the work that you create, you have copyright over it. You may try to apply for registration and you may be denied that registration. It doesn't mean that you still don't have rights over the work that you've created. It's difficult for you to maybe sue in federal court, but you still have a certain set of exclusive rights once you create that work. And the reason why this is helpful is because you have a lot of alternative routes to protect your work that go beyond just a federal court. And that's why it becomes important to understand the rights that you have associated with it. Sorry, I hope that that helps a little bit.
Yep.
Right. So the final requirement, and I think this may once again help in understanding copyright criteria and copyrightability of works, is the originality criteria. Now, you must be thinking that I just keep talking about how easy it is for photographers and for these other types of artists to protect their work. And the reason why that is so is because right now we've seen two interesting factors, that there has to be an author and it has to be fixed. But the third factor is originality. And this is really interesting because the originality requirement is actually really, really low. The work literally just has to have a modicum of creativity, and it needs to be in an independent creation of another. So what this means is that the requirement for copyright to exist is actually an extremely low bar of creativity, which is why two people can copyright almost the same thing, because as long as you didn't directly take it from somebody, and as long as it has a tiny bit of originality, that completely satisfies the modicum of creativity requirement. And a couple of courts, they have held that the requisite level of creativity is extremely low, and even a slight amount would suffice. However, there are certain cases where, of course, even a bit of creativity is not going to meet that standard. And the simplest example to understand this is the white pages section of a phone book. So the white pages section of a phone book, that doesn't have enough creativity in order for it to be copyrightable. But if you start to organize it in a little different way, if you organize it by lawyers, by specialization, or if you start doing a strange color-coded theme, you could likely get copyright protection as a selection and arrangement in that. So that is why the requirement for originality is just a modicum of creativity, and it is really low as long as it is a little creative and you haven't directly copied that from somebody else. And as mentioned earlier, this is the reason why ideas, facts, concepts, they aren't protected by copyright law, because you don't want to stifle that kind of creativity or that creation. Only the expression of those ideas and facts would be protectable. A very simple example, TV shows, period dramas. You have shows based on Queen Mary, the Tudors, on The Crown. So basically, people are able to create different stories on historical events and take and have their own spin on it. So you're able to get protection over that work or that TV show, but anybody else can also create it, because the originality requirement is very, very low. But to conclude this portion of the talk, at least in order for an artist to receive protection over their copyright work, it has to be bare minimum original, modicum of creativity. It has to be done by a human author, and it has to be fixed in a tangible medium of expression. Now, here comes a big portion of it that, great, what is the point of any of this? Why do you want to have copyright over your work? And why does it not matter if you necessarily register your work or not? Why do people care so much about this? It's because as a copyright holder, you have a bundle of rights that come with it, regardless of whether you register the work or not. Now, as a copyright owner, once you've created the work, you are the only person who has a right to reproduce the work. So this grants you the ability to control how a copy of your work is made. And it's probably the most important right that you have. And it's also the reason why it's so important is it's because it's probably the right that's implicated the most. Now, when we get to the discussion of fair use and infringement, we'll understand this a little bit more. But something that I want to tell you at the outset is that infringement is infringement, right? Now, you have all of these rights to reproduce the work, to create derivatives of your work, which means to create sequels, prequels, translations, other forms of adaptation of your work. You have the right to distribute your work, to publicly display your work, to perform your work. And the minute somebody else infringes on any of these rights, they are infringing your copyright. And this is actually very, very it's kind of funny because a lot of times people don't know how easily you're infringing somebody's work. Now, suppose somebody on the Zoom call takes a photo of my slides, or if you take a screenshot of a show that you are watching, or if you're in the movie theater and you take a photo and you upload that scene of the movie on your social media, you are infringing on somebody else's right. So you should know that even if you take a photo of a news article and you're sending it to somebody else, infringement. If you're copying a small paragraph on a website that you read and you share it with somebody else, you guessed it, infringement. Everything is actually infringement. And when we get to fair use, you'll see that that's an affirmative defense, which means that you have to be sued in order to use a defense of fair use, which means that at the outset, you're 100% infringing on somebody else's work. And this comes as a really it can come as a bit of a shocker to people because when you think that you're using something for personal use or nonprofit use, or you're not making any money out of it, you assume that, hey, I'm not infringing, I'm just doing this for myself, so it doesn't really matter. But you are infringing. That is the thing. And you may use a defense of fair use in case you are sued in court. And just by using a disclaimer, by saying that, oh, all rights belong to this person, no fair use, no infringement intended, that doesn't devoid the liability you have for infringement. It could be helpful if you're ever sued, but if somebody sends you a cease and desist, you likely would have to conform to that unless you want to go ahead in court and prove why what you're doing is fair use. But there are certain factors that make it helpful for an artist as well as for um, somebody who wants to pay homage to another artist. If you're really inspired by somebody and you're like, I would really love to do something which honors this artist. That's when all of these considerations come in and it becomes important to understand what fair use is. The reason why I always start by saying that it's an affirmative defense is because a lot of times we see people use it as if they are entitled to the work, when actually you are infringing an artist's work. And there are certain steps that make it a little more helpful for you to understand the rights that you may have to borrow somebody's work, to maybe appropriate somebody's work. A really good example of this is the very first image that I had shown you here. And this is an example where you can see that a court had held that while this was infringement, there was a defense of fair use, which of course made made this made Jeff Koons win this case. So we're going to look into a few of the factors which courts look at and for what artists should probably consider as well when they're creating their work, and very importantly, when you're trying to use somebody else's work in your work. Now, you have those exclusive rights that I mentioned over here, and this means that you are the only person who can use these exclusive rights over the work that you have as a copyright owner. But sometimes what people do, and what's usually done by artists, is that you grant certain rights to another entity. The book publisher example that I had mentioned, right? That you are the copyright holder, but you've licensed some of your rights so that an other person can bring your work to the market. Now, something that I just want to mention before we really get into fair use is that make sure that you are granting your rights, and in a contract, transfer of rights is not mentioned. Now, it's literally a change of one word, grant of rights versus transfer of rights. And this becomes so important because you're not selling your copyright. And as I keep mentioning, as an artist and a copyright holder, you are the person who retains copyright to your work. And you're merely granting your rights to another entity for a specific period of time. So ensure that in any contracts you have, double, triple check that there is no transfer or assignment of rights that's happening. And the reason why this becomes important is also because of fair use, which I'll explain a little bit more now. As I mentioned, fair use, it's an affirmative defense, and it essentially allows you to use the work of another person for a very specified purpose. But it is a defense, and it's not something which just exists like that. So the only way to actually get a definitive answer on whether your use is a particular fair use case or not is actually for it to be resolved in federal court. And you don't ever want to get there, but the judges use 4 factors in order to decide these fair use disputes. And I'll talk a little bit about them now. And you should always keep these in mind when you're creating work yourself, when you see that somebody else has either borrowed your work, or if you're inspired by somebody else and you want to include their work in yours. Now, there are 4 factors which are taken into consideration. The most important one is the purpose and character of your use. And this is really commonly known as the transformative factor. And at issue over here is whether the material that you have taken from the original work, has it been transformed by you in any way? Have you added any new expression? Have you added any new meaning to it? And did you add any value to the original by creating new information or new aesthetics or new insights and understandings? So this is what you consider that whether your work has commented, like how Jeff Koons' work had commented on consumer culture. Are you commenting on anything to make it a little more insightful? And under this factor, a lot of times the purpose of scholarship, research, education, this also falls under transformative. So a lot of times, like I have used so many images over here of different works that I don't have the copyright to at all. And, somebody could very well sue me for using these images, but they likely won't sue me because they would know that I am using it for educational purposes. And I am using it not for any economic gain. I'm using it to reiterate what fair use and what copyright is. So the transformative factor would play a very big role in my case if somebody sues me for using the works in my presentation. So that is something to consider. And a really interesting case for consideration is the Harry Potter Encyclopedia. And I'm not sure if anybody has heard about this case, but basically there was this Harry Potter fan who created a dictionary encyclopedia of sorts. It was a lexicon, and it basically included what certain terms in the Harry Potter series meant. But what the court held is that this was an infringement on J.K. Rowling's rights. It was an infringement on her exclusive right, particularly for derivative works, because it was essentially a spin-off of sorts of her work that she had. But very importantly, that this ate into the market of J.K. Rowling, and it was only slightly transformative. Essentially, everything was based on the Harry Potter series and on J.K. Rowling's books and her thoughts, her ideas, her expressions. So the fan unfortunately did face copyright infringement, and J.K. Rowling had won that case. But that is the first and most important factor of the work being transformative. The next is the nature of the copyrighted work itself. This is talking about the nature of the work that you are borrowing from. And as I've mentioned before, the dissemination of facts, information, biographics, historical data, if you're copying from those type of works, that would favor you for the fair use analysis because those are facts that exist. However, if you are copying from fictional work, from, once again, let's say Harry Potter books, then that factor likely won't favor you as much because the nature of that work is fictional. People have built upon it. It's not information that is just readily available to anybody. And also, if you copy from something that is published versus if you copy from something that is in a draft mode or unpublished. Of course, if it's in a draft mode or unpublished, it won't really work in your favor because the person has the right to first publish it. So that also falls under the nature of the copyrighted work. Whether it's historical, whether it is published, that would play into the fair use analysis. The third is the amount and the substantiality of the portion that you take from the other person's work. Of course, the less you take, the more likely that your copying would be excused as fair use. However, even if you take a small portion of the work, your copying, it may not be fair use if you've decided to take the heart of the work. So if it's a 500-page book and you take 499 pages, of course, that would likely not be in your favor. But if it's 500 pages and you take 5 pages, but that is the heart of the book. It's the principle that what the book is talking about, then that could still not work in your favor. It could still be viewed as infringement. And finally, the next factor is the use upon the potential market. That are you depriving the original copyright owner of a market? The case of J.K. Rowling and the Harry Potter Encyclopedia. The court did say that yes, J.K. Rowling had a right to first publish that because it's her derivative work and you're eating into a market that she should have been able to produce her work too. And a really important case, which I think would help understanding this, is Rogers versus Koons. Once again, we have Koons over here, Jeff Koons. And what happened here is that there was a photographer who had taken this photo on the left of an old couple holding a string of very cute puppies. And then what Koons did is that he recreated that as a sculpture and added color to it. And when the photographer sued, I should also probably mention that the photograph it didn't really sell for a lot, but the artist, Jeff Koons, had earned several $100,000 when he sold the sculpture. So that is also something to take into consideration. But when the photographer sued Jeff Koons, he claimed that his sculptures, they were fair use because the photographer had never ever considered making sculptures. The photographer had only taken photographs and that he is the one who created sculptures for the first time, so it should be fair use. But the court disagreed, saying that it didn't matter if the photographer had considered making sculptures or not. What mattered was that there was a potential market for sculptures that existed, and the photographer had the first right to enter that market. So this gives you a very wide prospect to see that when your work ultimately eats upon a market which the other original artist had a right to, then that likely won't favor you. But I keep mentioning that these are 4 factors that courts take into consideration. And while some factors may seem more important than others, it's really a totality of looking at all of these factors on top of that on a case-to-case basis. So we've seen so many different types of cases which I personally didn't think would be handled in certain ways of whether it would be fair use or infringement. Just yesterday, a really big AI case was decided for the first time, and this was about data scraping, and ultimately the court, for the first time ever, held that Thomson Reuters, which is a media company, they created Westlaw, and they have databases of cases that when an AI company had used those cases to feed and to data scrape and to feed its systems, that was not fair use. So this was a really big win to show, and this is literally the first time we're ever hearing a case decided on this basis right now. But damages are being awarded to Thomson Reuters. So it's going to be interesting to see how all of the other cases play out. One of the biggest cases you may have heard of course, is Warhol versus Goldsmith. And I wouldn't get into the details of that because we'd probably need another hour. But the biggest takeaway that you could understand from that case is actually that everything is to be decided on a case-by-case basis. So if there's anything you can take from it, it's courts can go in any direction with these type of cases. Very quickly, I'll also mention something related to museums and the concept of fair use that museums might have to face. A really fun case to look into is Murano versus Met. And basically, what the Met had done is that they used an image on their website in connection with an exhibition they had at that time, which focused on instruments of rock and roll. And what the Met did is that they included the Frankenstein guitar, which is, of course, the guitar that Van Halen plays. And what the court did in this case, they analyzed whether the Met's use of this photograph on their website was fair use, whether it was infringement, and whether it was violating the photographer's rights. So what the court found at the district level was that the Met's use of this photo for the guitar, it was in a very recognizable historical context. It was meant for a scholarly purpose in order to show people that, these are the instruments that really big musicians used and what they would play for their concerts. So they held that this was a historical context, it was a scholarly context, and only a minimal part of the photograph was used. It was still very pixelated. It wasn't a high quality image at all. And ultimately, Murano, they appealed, and the higher court, the appellate court, they held pretty much the same thing, but they added something that the commercial use should also be taken into consideration. At the lower court, they held that it is fair use, even though that it was a commercial use of the image because the Met earns money when visitors come in. But then the appellate court said that how can you say that this is commercial use when this image, it's not being used in the Met, it's being used on their website. This is publicly accessible to anybody without paying any money. So they said that we completely agree with you that this is a historical context, it's a scholarly context, but also this is a non-commercial use because nobody needs to pay money in order to view the Met's website. So the fact that you're showing it in a really low quality pixelated image is absolutely fine because you're trying to show a very historical context of what musicians and artists used, what were the instruments for rock and roll. And I know I'm running a little out of time, so I may conclude a portion of this by just ending with social media and copyright. And if there are more questions, you can let me know. I'm so sorry. I didn't realize it was already 8:10, but I would like to really talk about social media considerations because it's getting incredibly complex for artists to showcase their work. And I wanted to take this in the context of fair use as well, because now you know what copyright is. You know that you don't have to register it, but there are certain benefits that come with it. You know that you have exclusive rights to your work, whether you register it or not. And you also know that there's a concept of fair use. So when somebody infringes your work, they may be using it in a fair use context. And the reason why social media becomes important is because we are bringing everything that we just learned right now to this concept. That now what you're doing is that you are showcasing your work to the whole world to see. Anybody can screenshot your image. Anybody can essentially do what they want with your work. So does that mean that you lose control over your work? Does this mean you lose authorship? You lose ownership over your work? And I think a really fun way to explain this is with an example of Richard Prince, who is once again a very well-known artist and appropriator. And what he did is that he turned borrowing online images into high art and very hard cash. So he had this portrait series, and it comprised entirely of Instagram photos of others. So he would go to people's profiles, both celebrities and just regular public profiles. He would screenshot their photos including their captions, and he would blow them up into larger than life proportions. And he would only add one element of alteration in the form of a very bizarre, lewd, and emoji annotated comment. And he would make that beneath the photo. And he was like, yeah, this is my work. It's fair use. In one of the memorandums he had submitted to the court, he stated that the artwork, it's fair use because it also gives a very Alice in Wonderland type of feel. Now, a lot of people were very upset at this, of course, because their images had been stolen and Richard Prince was making $200,000, $300,000 out of each of these images, these artworks that were posted. So Emily Ratajkowski, who is an actress and she's a model, she got very upset about this particularly. She didn't like what Richard Prince did, and she was particularly upset because what she stated is that some old rich white man had a very intimate photo of her hanging in his living room. And she got very upset about that, saying, how could my work be blown up into this? And this guy, the artist, has earned $200,000 from it, and somebody else gets this very intimate photo of me blown up, which is not what I consented to. So what she did is that she bought one of Richard Prince's photos of her. She stood in front of it. She took a photograph of it, of her standing in front of it, and then minted that photograph into an NFT so that she could take ownership of the work. And when she did that, she did essentially buy back her image in some way because she appropriated Richard Prince's work by her standing in front of it and minting the photograph, which included his work into an NFT. And Richard Prince said that he was very amused by it and it was a smart move. And essentially, she did exactly what he had done to her. So it became a very interesting question, but also a very novel way to see how people deal with appropriation and infringement when they don't necessarily want to sue or they don't want to go to court or get get the law involved. But this really begs the question, and I gave this example to show that with social media and with the work that you can share with other people can take your photos and what can they do with it? Can they use it? What exactly can they do with it? And very importantly, who owns it? Do you still own it? Does the platform own it? Are you infringing on somebody else's copyright? Are they infringing on yours? And do you have the right to take any action when you're putting your work into the world like this? And the answer is unfortunately just not as straightforward as we hope because there's no one law that we can follow as of now, but there are various sets of terms and conditions that each of the platforms dictate. So it actually becomes really imperative to read and understand what you're agreeing to when you sign up on these websites. And the truth of the matter is, a lot of us don't read them because you're often not allowed to use a social media platform at all unless you click agree and move forward. But over here, what the terms and conditions essentially state is that all of these social media platforms, they require users to sign terms of agreement to engage. And these are click wrap agreements or click through agreements. So you're agreeing to them in order to use the platform itself. And one of the main one of the main terms that you agree to is that you enter into a licensing agreement with the platform. And this allows the platform, whether it's Instagram, TikTok, it allows the platform to use your work in a way that they best see fit. And one of the biggest ways that they can use it is for advertisement purposes. And I mean, they're never going to ask your permission to use it, let alone if they start earning from it. You're likely not going to get much money off of that. But just because you've entered into a licensing agreement with the platform, it doesn't mean that everybody else has the right to use your work too. So if somebody else uses your work on social media, depending on the situation, you do have the right to sue for copyright infringement. You may be able to claim some legal action, monetary damages, because just because you've entered into this agreement with the platform, all of the users, they're independent. And if somebody takes your work without permission, they are violating your copyright and you can potentially take action against them. Something to note is that you have the DMCA. It's the Digital Millennium Copyright Act. So usually when you sue some other person for using your work on social media, you can never really enjoin the platform. What the platforms have to do, they kind of get a pass because under this DMCA, they have to provide a method for you to redress your copyright concerns. And all social media platforms have that. You have an option to report whether somebody is infringing your work, copying their work, whether they're impersonating you, and so forth. So because they have those checks and balances in place, a lot of the times the social media platform itself would not be held liable. But something that you can do to protect your work is, of course, registration, ensuring that there's a copyright notice on your work. Very particularly that even though sometimes a lot of artists say that when you have a watermark, it reduces the appeal of your work, having a watermark can be really, really helpful because Section 1202 of the Copyright Act makes it illegal for somebody to remove a watermark. So even if somebody is taking your work without your permission, if you realize that they've removed your watermark, you have an even higher standard to get damages and to take action against them. Very simply, when you're resharing the work of other people on social media, ask for permission, give them appropriate credit. Here's just a very quick slide of a few things that you can do and what you shouldn't do and why you should take certain actions when you are either sharing your work or you're resharing the work of another artist on social media. But essentially, if your account is a public account, you should be mindful that you do lose a few rights because if you have a private account on certain social media platforms like TikTok or like Instagram, then your rights are slightly higher protected because it's not available to everybody. But even if you have a public account, remember that all of the work is your work. Only Instagram or that social media platform actually has a right to do something with the images because of the licensing agreement. Anybody else, you can report them. A lot of times we've seen that the threat of legal action, and even before you get to the threat of legal action, reaching out and amicably asking somebody to remove the post or asking to give credit so that people can go back to the original artist and maybe purchase work from the artist, it can be very helpful. Ultimately, what we've seen is that artists want their work to be shown. They want people to see it, appreciate it, and that can happen. It's a double-edged sword when it comes in today's world where social media is, the world runs on social media. It's the one way that you can go viral, have a lot of subscribers, you can have a lot of new clients, but also your work is out there and people can very easily screenshot it and reproduce it. You do have a lot of options in place, and I won't get into the details now, but for additional reading, if anybody is interested, especially because of the rise of AI and AI companies stealing artists' copyrighted work so that they can feed it into their systems and train AI based on the artist's work, there are two incredible platforms. One is known as Nightshade, and it's a data poisoning tool. And essentially, what it does is that it tricks any software into thinking that your work is a different work. So it messes with the code of a digital work. If you have an image of a dog, Nightshade, it tricks the platform into thinking it's an image of a cat. So it can never actually be reproduced because it's showcasing something else. And the second platform I would recommend for anybody who's interested is looking at Glazed. And Glazed is really important for artists too because it protects the look of a work. So if you have, let's say, an impressionist painting that you've made and you want to protect it, if you use this platform called Glazed, it tricks the software into thinking it's an abstract piece of art. So once again, the actual work is never copied. And a lot of these are two of the biggest ones that have that we have come across, but it is so helpful because more than anything, artists can now at least ensure that their work is not directly copied or directly infringed. A couple of other quick things to take note of if you see that somebody is infringing your work. You, of course, can reach out to them and ask them to take it down. If they don't listen and if you need immediate action, you can issue a takedown notice. And all you have to do for this is that you have to send a DMCA takedown request. And the most beautiful thing about this is that your work does not have to be registered at all. It doesn't have to be registered, no copyright required. And the minute you issue this takedown request, the platform has to take it down. And then the other party, they can appeal and they can request for it to come back up saying that, hey, there's no infringement here. but that takes time and it gives you steps to either plan what your next steps are going to be if you want to register your work and sue in federal court, or a lot of the times it's resolved at this stage itself because they know they're infringing and they don't have the energy or the time to pursue an appeal to get the work put back up. There are a lot of other issues that we are seeing related to AI art, infringement, data scraping, uh, data privacy as well. But I'll end the presentation here with this last image. And when I had moved to New York back in 2021, this was during COVID, I visited the Met, and I was so taken with this artwork here. It was by Kent Monkman called Welcoming the Newcomers. And the really cool thing about this work is that it referenced 13 different works and different characters that were in different paintings in the Met itself. And what the artist Kent Monkman was trying to do, he was trying to comment on climate change, on immigration policies, and pollution. And this particularly comments on immigration, but you might see that they're really similar. It's very similar to a lot of paintings that we might know of. And I just thought that this is now, it's never gone to court or anything of the sort, but it's a great example of what fair use could be, that you're taking works that are likely copyright protected. Some of the works may fall into something known as the public domain. As a note, whenever you register copyright, you have copyright protection for the lifetime of the author plus 70 years. After that expiry date, it goes into the public domain so other people can feel inspired by the work, which is why Steamboat Willie, Mickey Mouse, is actually now finally in the public domain. So you'll see that people are able to make movies and characters and different images using Steamboat Willie, but not the other iterations of Mickey Mouse. But yes, I hope this has been helpful. I'm sorry if it ran a little over time. And
We do have one more question. Um,
Mhm.
does mint our artworks as NFTs count as copyright?
Yes. So NFTs has been a very contentious topic for a while. Generally, owning an NFT, it doesn't mean owning a copyright to the underlying artwork. When you buy an NFT, you get something that's known as a unique digital token, and that's recorded on the blockchain, but it doesn't necessarily give you the right to reproduce, to distribute, or to create derivative works at all. Copyright, it does remain with the original creator unless the copyright has been explicitly transferred. However, it grants you not copyright registration or copyright ownership. It grants you ownership in the work that you have. And in the case of Richard Prince, this was a very unique situation because it was Emily Ratajkowski's photo in Richard Prince's painting or in his artwork that was then taken, Emily had taken a photo of her with it. So once she had copyright to the photograph, which contained Richard Prince's work in the background, and then she minted an NFT of the photograph that was taken as well. So I wouldn't say that copyright is automatically granted when you mint an NFT. This is something that needs to be licensed and explicitly stated. What we're seeing a lot right now is that in artist contracts, especially in licensing and outright agreements, a lot of artists are stating that they have the right to create an NFT of any photo or of any artwork that they produce. So unless that right is explicitly granted, you should not assume that minting an NFT would give you copyright ownership over the original artwork.
I have one question just in terms of if someone was interested in copywriting, say, a piece of art or a photograph, what is that process like? Is it onerous? Does it cost a lot? Is it a simple form? Like, how does that work?
Course. So it's actually a lot easier than people think it is. And it's a simple process by going on the Copyright Office's website, and you'll have an option to select which type of work you want to register, whether it's a visual art, under visual art, whether it's a sculptural work. And it's not as expensive, once again, as people think it can be. To register an individual work, it ranges from $25 to $75, and it can be done without an attorney. The only frustrating thing is that sometimes forms can be a little overwhelming, and you do have to fill in many of the little boxes, but it's very simple. Uh, it's easy information, and the Copyright Office even has a guide that takes you step by step on the different boxes you need to that you need to fill in. And a lot of the artists that we have seen, especially some of the artists who are working with AI to register their work, all of them have registered their work independently without the help of an attorney. So, in case anybody needs any help, both in terms of registering a copyright or two, issuing a DMC takedown notice, there are very easy tutorials available on the Copyright Office's website. And once again, you do not need an attorney to do this. And I will also mention that for certain claims, if it's less than a certain amount, I think $25,000 or so, you also can represent yourself and you can go to a small claims court rather than sue in a federal court where once again you don't need an attorney. So I just wanted to add that in because the process of registering a copyright is a lot easier than people think it is. And all of the information is readily available on the Copyright Office's website.
And I think we have one last question. Deborah, you have your hand up?
Yes, I'm a choreographer and I've had my work co-opted in a number of ways. One thing is, I do a lot of community performances because we have funding from the county, and um, even in big theaters, I've seen people with their phones taking pictures and videos. I mean, I've seen it like at the Met. People are outrageous. But anyway, in a small theater, people just tape the whole thing on their phone, and sometimes they're taping their wife, their friend, that whatever. That's fine. I don't mind that. It's how they use it. They've also taped classes of mine, and I have a certain class that I do, let's say, once a year for a specific occasion, and they just use it. I've seen people, they write grants using my materials that they've either taken off my website or they've videotaped it. And sometimes I'll be hired and I'll do a specific piece for a school or an organization, and then they just use the video for years and get money to produce it, and they don't tell me, they don't get my permission, and they don't pay me, of course. It's very, very hard to combat this. And, it is an ephemeral art form. And I don't always get great videos of everything that I'm doing. I do certain shows at certain times of the year, and I do premiere new things. How does one protect oneself in a case like that? Because it's hard. And then, of course, even Balanchine himself, one of the greatest choreographers of the 20th century, said he changes his pieces all the time, depending on who's doing it. And that's true. When I change my cast, I usually change the choreography slightly because it looks different on a different person. So you could say, that's not the same. She did something else over there in that part of the music. How does one protect oneself with choreography? That's what I'd like to know.
Choreography is probably one of the most difficult forms of expression to protect. And it's unfortunate because the Copyright Act, it explicitly does state that choreography falls under a protected work. And you have the same types of criteria required, that it needs to be original, minimum level of creativity, and fixed in a tangible medium. The issue is very similar to what you're saying, that this tangible medium is usually video recording. And what has become really frustrating, that what we've seen is that particularly in the last few years, especially with the rise of TikTok and social dances, a lot of social dances, short movements, gestures, ideas, or concept for dances, they're not really protected. And you do have to show kind of extensive video documentation and dance notation of how you are going to protect your work. And when you do submit choreography registration to the Copyright Office, you do have to send in that video. A lot of times what we recommend, because there's so many issues with copyright for a lot of types of these works, is having agreements and contracts in place, having choreography agreements and licensing and performance rights. Those are probably the best ways to handle this. In a dance studio, for example, I'm not sure if you have any policies about recording the work or for what it can be used for. Now, the thing is, while you may not be able to necessarily always prove that you have copyright in this and you have copyright in this and in this movement, if somebody is in violation of their contract, you have a contractual clause that you can actually sue them under. And personally, I feel that that is probably the best way to enforce to enforce choreography rights, because under copyright right now, it is extremely difficult to prove it. I would say that historically, in several cases, and very recently, they managed to show copyright protection for dances in Fortnite in video games. So it is interesting to see the extent of which protection can potentially be granted. But on a real life basis, we were working with this ballet studio, and they found it incredibly difficult to enforce any of the rights that they had. So now,
They
for any
did.
of the classes that they have, we have recommended to have very stringent contracts, and when they enter, they have to sign in. It's an online agreement that you agree to so and so, that one, they can be recorded for your purposes, but they don't own any of the rights in what they do. And if you do allow them to record for personal use, if you have somebody who regularly checks the work that you're doing with on Google, reverse Google searching, and if they're able to find something, you're at least able to bring a contract action against them if it's not a copyright infringement violation.
Yeah, I hear you. First of all, notation is beyond the means of all but the major dance companies. It's exorbitantly expensive. And, nobody's going to sign a contract like that at the level that I'm at. I teach college. I'm a college professor. I don't have a studio anymore. I went back to school. I have a doctorate in health education, and I've combined wellness and dance in a lot of what I do. It's just, I'm very generous with my time, and I do a lot of charitable things for poor populations and underserved populations, but I have people trying to get things that I've put together and like, let's sell it, let's make money off it. I'm like, come on. Now, on the other end, I have a question about my usage and other people's usage of music. Okay, I do something in Florida every year for Martin Luther King Day, and we march. They get community service, and then they had performance at the museum. And the young kids have organic gardening, and they learn fitness and nutrition through gardening and dance. Anyway, for the first time last year, they stopped playing the I Have a Dream speech. They usually play that at the beginning of the march, and they said that there was a copyright issue. I guess the city of Boca Raton, which is very wealthy, did not want to pay for it. This year, they
Mhm.
didn't sing the Black National Anthem either because of copyright issues, which I found. I mean, why wouldn't you sing it? They sing it every Martin Luther King Day. And so sometimes copyright can work against things. Shouldn't that be widespread? Everybody should know that so they can participate in it in Martin Luther King Day and Juneteenth and other things celebrating Black history. So I I wonder, I don't know how much the King Foundation or whatever was charging to use the I Have a Dream speech, but I think every generation should hear that and should learn from it. And I think today, especially, we live in such a violent world. I promote the values of peaceful coexistence and positive social change using nonviolence, but with myself, okay, with music. I was supposed to use all live music this year, and one of my players did not make it. He just was not up to it. He had showed me old stuff from an old website. So I used a combination of canned music and live music, which worked very well. It was free. It was part of a free event funded by grants. There was no admission to anything. And the music itself was not copyrighted because it was from the 20s. It was celebrating also the centennial of Boca Raton. But the recording was borderline. It was an older recording, but it might have had some copyright. I don't know. What
Mhm.
about if you're doing a free, it's sort of like an educational, community-oriented free thing? Every recording, do you have to get the rights to the recording or to the music for every single thing for an event like this?
Mhm. Usually for wide scale public use, the difference between music and visual arts, you usually require some sort of mechanical license at least for music. And a lot of times it can be complicated because you do require some kind of a license. And what we have seen a lot of musicians do is try to get a license to record cover music and cover versions of songs, because that reduces at least Some it gives you a little solace for the recording in itself if you're able to create something different. But even for an educational event, if it's public and if there is, um, I would say the criteria for music is what constitutes a public setting. And usually if it's more than 20 to 25 people, you likely require some sort of a license. And this is also similar in terms if you want to broadcast a small, like a movie with a large group of friends, you even see issues there, and you need to get a
Yeah.
license for something as trivial as that. In a small home theater, if you have more than 20 people, it likely constitutes public use and you would need a license. So unfortunately, the best way that we have gone about this is what you were saying. We recently have been trying to work on some music for different podcasts, and we buy royalty-free music, even though you do have to pay a small sum for it. But
Yeah,
more than
I've done that.
anything, we have worked with a lot of students. And a lot of students at Tisch, especially, who are very eager to show their work to the world. And just as an example, we're also a very small nonprofit organization, so our budget with a lot of these things is limited. So I'm sure that you have probably tried a lot of different, from what it sounds, a lot of different things to find the right music and see how you can go about this. Working with students has been very helpful for us to promote their work and also get relatively low cost commissions, cover music, and to create something that we're happy with. But I would say that unfortunately a license is probably needed for most of the uses that you have mentioned.
Thank you so much, Atria.